All right. Good afternoon, everyone. This is Curt, and welcome to another edition of Fire Law Roundup for August 29th, 2022. Brad, busy week here. Why don't you go ahead and take us away while I...
Yeah, this is going to be some complicated stuff, some really interesting stuff, but we got to start first where, unless you've been living under a rock, you should know Kobe Bryant. And yeah, I know we think this is like a famous issue, but this is an issue for the fire service, period. This is a big issue. And I love the way you describe it on the blog. People should take some time and read it. It's important, but we're going to summarize it. So as you know, Kobe Bryant and a family friend and family died in a helicopter crash. The county first responders arrived and for some insane reason started photographing dead bodies. I will never understand why, but not for me to understand. In any event, so as you can imagine, there was a lawsuit. We know and we're going to look at the lawsuit very much in depth now because what they alleged and the jury ultimately found is critical for fire departments. And let me just say this. You cannot any longer, if you were before, you cannot turn a blind eye to whether you have or do not have a policy on photography and talking about photography. All right. What we're about to go through, this case mandates, right? Basically mandates that you properly train your employees on a proper policy regarding this and similar types of action. So, okay. So the action we're talking about is photographing dead bodies. Now, there are some states, as we know, New York State is waiting the governor's signature on a law that will, it hasn't been signed yet.
Hasn't been signed yet?
Has not been signed yet. Everyone made a lot of hoopla about it.
Most places, if the law isn't signed, it goes into law automatically.
Yeah, pocket veto, 90 days. I don't even know that it's been sent to the governor yet. So that's when the time would start. In any event, but some states have or are going to have laws on taking pictures and then posting them for no valid purpose, etc. This didn't even go that far. This was, they took pictures, right? Let's go through the facts. So the helicopter crashes, first responders get there, they take pictures, they're showing pictures at the bar and showing pictures to people. Also, there was an allegation, I guess proven, that the employer, the county says, hey, if you just erase them, it'll be fine.
And that was by the sheriff. That was the county sheriff who told them that. And let's be fair to everybody here, because I don't want to throw anybody under the bus. This was not just firefighters. There were firefighters. Please. There were officials of the department, such as a captain who was serving as a PIO, that took some of the pictures as well. And there was some sort of approved pictures as well. But then there was a question about the use of those pictures. So, but we had sheriffs, deputy sheriffs, and we had firefighters from LA County that took. And when I teach this, okay, and I think it's a really important point here, we separate two distinct things, the taking and the sharing. Okay, two distinct things. There may be situations where taking is fine. That taking isn't the problem. Okay, right. It's the sharing that gets us into trouble. Okay, so it's important, I think, to keep a laser sharp focus on those two. And our policies need to reflect, we need to control some of the taking. Okay, we need to control all of the sharing.
Right. And look, a valid purpose protects the taking of it, right? So here, maybe the FAA hadn't arrived, and before you extricate people, or you want to, maybe it helps preserve what happened to the scene, car accident cases, things like, right? So there's valid purposes certainly to the taking, but here it was about the sharing. So here what happens is they sue under, among other things, Section 1983 of the Constitution, which basically provides that somebody who is acting under color state law, like a sheriff or a county or municipal firefighter, deprived another person, and here the Bryants and the family friend, of any immunities or rights or privileges that were granted under the state constitution. Very general. So here we have a more specific allegation that the county firefighters, police, etc., violated 1983 because they had policies that and see the double negative here, but they had policies that failed to prevent the violations of law, and that they failed to train or properly train their employees on the proper procedures. But let's make it simple. The simple part is they had no policies that prevented this behavior, and they failed to train people, their employees to prevent the behavior. And the behavior we're talking about is pretty much sharing of the very, very, confidential and graphic pictures. So the court goes through, which we should hear because it's extremely important for everyone to understand. In order to win on a 1983 claim, right, then you've got to show that, you failed to train on policies, but you also either had failed to implement policies or effective policies, right? Having a policy that does nothing doesn't help you. Having a policy that's ineffective does nothing, or having effective policies that you then don't train and enforce. And I'm adding the enforce. This is more about training here, but you got to, right? You got to have the whole package. Got to have an adequate policy. You got to train on it, and you got to enforce it. So here they said, listen, your policies that you had obviously weren't effective, right? And that's pretty easy to prove because nobody adhered to them, and they obviously weren't effective to prevent this violation of your constitutional rights. And they also had to prove, as part of this claim, and this is the harder part, truthfully, that the municipalities, the defendants, were deliberately indifferent. They intentionally didn't care, right? And because they intentionally didn't care, or they were deliberately indifferent, that there was a substantial risk that the policies wouldn't be enforced, or that they were inadequate to prevent these violations of law. And finally, that the municipality should have known that because it was indifferent and had poor policies and didn't train on them, that there would have been a violation. So let me switch this for a second. Switch the fact. So ultimately, 16 million to the Bryants. It may have been reduced by $1 million.
I think it was reduced by a million. So
yeah, I just saw that. And then 16 million, or maybe 15, to the families. There had previously been a settlement, I think, of 2.5 or something. But
there was a total of 4 suits by the families. There was, I think, 16 people on the helicopter, whatever it was. But there was a total of 4 suits. 2 of them were settled for 1.25 million each. So that was a total of 2.5 million. And the last 2 were decided in this jury trial that ended last Thursday.
Yeah. And look, imagine being the jury, because imagine yourself in front of a jury when they hold up the picture and say, should this have been distributed? End of case. I don't care what you think and I'm sure there were objections. I didn't watch, but I'm sure there were objections saying, you're just swaying the jury. You shouldn't introduce the pictures, too graphic. Tough. You put them out there for everybody to see. You're not going to be able to say the jury couldn't see them, which I think is one of the parts of this. In any event, the deliberate indifference is so important to talk about because, look, if the county, let's say they had a policy that says you can't take any inappropriate pictures unless they're needed for a valid purpose, and if you take them, they have to be stored carefully, can't be distributed. Let's assume the county trained everybody on that. Let's assume there was a termination clause in there. So they said, if you violate this, we're going to terminate you, no questions asked. And let's assume they conducted adequate training. Mm-hmm. If those were the facts, this may very well have gone a different way. It's not.
It may not have happened in the first place.
Well, right,
okay,
right.
That's number one, right? And then, but if it did happen, the city's or the county's in a better position to raise the defense. Absolutely.
Right. So, and listen to the viewers. Curt and I are not saying, hey, just put a good policy in place and ignore it, because that's the deliberate indifference.
That may be what happened here as well. I don't know. I haven't seen their policy, but that may very well be.
Right, right. But everyone should be taking notice of this case. This is definitely the case to highlight for this week for our short, but everybody should be taking notice and you should be going back and saying, would we have acted the same way? Do our employees know not to act the same way? And please do not anyone say, well, common sense dictates. This is right. Because I've heard that. Well, who would do that?
I know. Oh, our guys, our folks are all mature. They would never do something like this. Okay. Yep.
Yeah, leading us to all the next cases.
Yeah,
so,
right.
Okay. So
now, I do want to point out that the consequence to this was also the enactment of a criminal law, making it now in California a criminal offense to do what these folks did.
And in New York soon too.
Right. And now New York has one pending. I thought it had already been enacted, but it still is hung up in the bureaucracy,
Governor's
our
desk.
wonderful bureaucracy. But New Jersey and Connecticut are two states that have a law that prohibits this kind of picture taking and criminalizes it. And the reason I want to emphasize that is if fire service leaders don't address this problem and get it to stop or manage it, then all 50 states are going to end up enacting criminal laws that make it a crime to do what they did here. We don't need that. I don't think that helps the situation. If we do our jobs as leaders, we can prevent this from becoming sort of a national trend. Okay. Right. If we want to look the other way at it, if we want to be the fire chief that, oh, well, I don't want to pick on my people. I don't want to have these kind of rules, right? If you want to be that kind of a chief, then guess what? The end result is going to be your state legislature enacting a law that makes it a crime, because that's how state legislatures fix problems.
Right. Just like OSHA, if you don't want to fix things, we will tell you how to do it. But I really think that people have to understand that training is such an important corollary to policies. Having a policy is like 10%, but training people on it constantly is 90%. And I always think there should be a training day, and maybe it takes 8 hours, whatever it is, a training day, summarize the most important point from each policy, because people aren't going to remember all of them, but you highlight them every year. And here would be simple. I could summarize this in a sentence. Don't take pictures, when you don't need to, and don't show anyone. I mean, how hard is this?
Right. Until it, we could spend an hour on this one, and I don't want to belabor it, but I'm a big fan of picture taking, but we've got to manage it. And there's good news about picture taking, because when you're a firefighter and you go to a fire, you go to a helicopter crash and you take pictures, those pictures may be public records. Okay. And now once they're public records, you can put in a request to get a public record and it can be used. So the good news is if your department allows you to take pictures and the pictures are within the public records law, then you can use them. And that's a good thing. That's a positive thing. Now, the downside to that is the department needs to manage that. And if there is something objectionable in the picture, then the fire department, just like any other public record, they have to redact that from the picture. And then the firefighter can use what's not redacted. So the good news is you can take pictures and use them as long as you follow a good policy that respects people's rights and your public records requirements.
But you do it on a personal cell phone and a whole different slew of issues, right? And we won't get off. We won't go there. But
now we'll start talking about Tom Brady and his cell phone. And
all right, we won't go there.
Yeah. So
let's go to the other warm state, which may be every state this year. Let's go to Florida.
The one that's having a drought. How about the one that?
Everybody's limited down to 49. Not Texas, apparently, this week.
Yeah, that's true. Well, Kentucky a couple of weeks ago, right?
Yep, Mississippi. Okay, let's go to Florida. This doesn't have to be ridiculously complicated. I can pretty much summarize it. But here, the Florida's appellate court ruled that when a fire chief, as part of his job responsibilities, reports on matters to the public and issues a public written or oral or both statement on that matter, that you can't be found, you're immune from defamation. Right now, let me be careful. This doesn't mean, and I'll give you the facts really quickly, but this doesn't mean that just because you say something that it's automatically immune, right? If you lie, lying is not going to be in your job description. So here, every attorney knows that truth is the ultimate defense to defamation, right? When you say something and it's true, you can't be sued for defamation. This wasn't the holding of this immunity decision, but you can bet that if it was untrue, the immunity would not have applied because lying is not part of your job description. So here, basically, there was, I'll summarize it because it's horrible.
I'll give you the facts if you want, because I'm familiar with what happened here. And we had It sounds to me like it was a prank gone wrong, but it was also on
pranks gone wrong.
one, yeah, on two pranks. On one level, it could be pranks going wrong. On another level, it could be blatant racism. So which of the two, we'll leave it to folks to kind of work their way through. But we're at the city of Miami. We've got, I imagine one shift led by one lieutenant decides to pull a prank or harass a lieutenant who's African-American on a different shift. And he apparently left some family pictures out. So the firefighters drew some phallic symbols on the pictures. Okay. So that's sort of prank number one. Couple of days later, someone else, and whether it was a noose, whether it was a piece of string with a knot or whatever it was, but there was a piece of twine or whatever that was shaped like a noose that was draped over one of the pictures. So two separate events over 2 different days. And the lieutenant, the African-American lieutenant now comes back, sees the defamed, the pictures, sees the noose, is offended, contacts the department, complains, and an investigation is launched. And I believe there was somewhere between 11 and 12 members that were involved, some level of involvement with it, 6 of whom were terminated. Okay, at the conclusion of the investigation. The investigation pretty clearly said some of them only drew the phallic symbols. Someone else did the noose. Okay, so what we've got now is the 6 firefighters were terminated, several others were disciplined. There was appeals, there was suits off to the side of that related to this case as well. 3 of the firefighters who were involved in drawing the phallic images, they weren't involved in the noose, but they were involved in the phallic images, filed suit against the fire chief in the city of Miami, claiming that they were defamed because when the chief made public statements about the incident, he didn't make it clear that there were 2 groups here, and they felt that their reputation, their ability to get jobs in the future now were going to be jeopardized because they were being labeled as racist. And they feel like what they did may have been inappropriate, but it wasn't racist. So they sued the chief and the city for defamation.
And look,
all yours now.
Well, no, it was defamatory, right? If I think that rises to the level of defamation, but doesn't matter, right? It was true. It may have not been said perfectly, and maybe a private person would have lost if they said that. But here, very simple. They said the fire chief's acting in the scope of his duty when he reports on this, and that's the end of it. He's immune. Yeah,
so the chief statements were made public. One was in writing, one was at a press conference, but they were made publicly. So what could change this? Let's say the chief made the same statements, maybe not in his official capacity, but maybe to someone on the side. Right. Not as part of his official duties. Well, then you have a question of fact whether they were in his official duties, not, and all that. The immunity might not apply. But here, he made the statements in his official capacity, and he has immunity for those statements.
Right. That's really all we need to say. Okay, let's go to Wyoming. This one, the facts are so easy.
I would like to use this one in a class, and I would like to ask how many people in the class have never barked at someone for needlessly calling 911. Okay, I think we've all done it.
Right. Okay. And look, it's frustrating, especially when it's at night. It's at the end of our shift. We want to go home. I'm throwing that in because these are some of the facts. But here, look, simple facts. There's an individual in a wheelchair. The individual in a wheelchair has a catheter and is in a controlled wheelchair with a motor and is utilizing 911 services for administrative assistance. Although I got to tell you, my fire department, probably every other, goes to catheter calls constantly, clog catheter, et cetera. Right. So we know how to clear them. We don't want to, you don't want to transfer someone to the hospital. But after a while, it's not an emergency, right? A clog catheter, I suppose, could lead to infection, could be stuck under a wheelchair, could be an emergency. And I use those because those were 2 of the things that got this person out of bed. They're very upset. at the dispatcher and at the patient. And after they go, and they're screaming profanities every time they got called, no problem with that. Scream profanities in your bunk room or in the station all you want, as long as the public can't hear. But ultimately then the captain or the individual scolds the patient. Now, if we change scolding to instructing, which I want to do at the end, maybe we have a different issue. But scolds the patient and then basically brags about it. Somebody reports it and the individual is fired. That's really the interesting part. I mean, the rest of the facts, which I'll tell you now, aren't really that interesting. They went through processes. It wasn't done right. Prior to a final termination, they correct the processes, giving the chance to, a notice of charges, a hearing, a right to conduct discovery, all the things that somebody should have as part of due process. They were given before a final termination, and the court holds, maybe you screwed up before, but before a final decision was made, it was all corrected and you're fine. That's the legal part about it. But the more interesting thing is why the person got terminated. And yeah, I think if you yell at your patients and say not to call 911. Now, what if I propose, because I've done this on scene, sir, just so you understand, this is not a true emergency. We would suggest you call any one of these services. And what I've done and urge clients to do is, and here's a list of those that are more appropriate to call, right? Give them an alternative other than 911, because it's not hard to remember 3 digits. So, and then you're helpful and say, it's really not appropriate that you call us. If you do, we'll come, but please try these other services first. And you got to keep trying to educate somebody. Instructions is different than scolding, and scolding definitely provided a basis to terminate the person. And look, I kind of put this a little bit on the municipality. When I was fire chief, I provided instructions to people and, provided other numbers to hoarders. There was a hoarders group, right? And that's a public safety issue. But, before we just say we're not coming, let's at least say, hey, here's how you can help yourself.
I think a lot of police departments now are hiring social workers and psychologists to help them on the types of repetitive calls that they get. And I really think many fire departments need to, maybe you don't need a full-time social worker, but you need some sort of referral, like you suggest, to some sort of social service, because these people, if somebody's calling for an ambulance more than once a week or so, and maybe that's not even a good way to look at it, but you have somebody's calling, we have people call 3 or 4 times a day. They should not, that's an indication that they should not be living by themselves.
Right.
And nobody wants to deal with it. So it falls on us. Now, I don't know all the facts of this situation, whether or not this person was calling that much, but I mean, we had people, calling literally 3 or 4 times a day. Many of these were homeless.
Right.
And, that becomes a burden. I've talked to some of our medics, and, they're going on this needless run to somebody who abuses the system. And then 30 seconds later, there's a child choking right around the corner from their station. And they're like, this isn't right. And then they bark at the person when they get there. You realize a kid may die because you called, so I get the frustration. I understand that part of it. But that you're absolutely right. It's a leadership responsibility, and it can't be fixed by that medic. There's no amount of talking that medic is going to have with that person is going to fix the problem. It's a leadership issue. Leadership has to engage on this and, address it. So I have a lot of sympathy for the medic here. I think what we don't know is her choice of language.
Right. Right.
And, just like in a baseball game, you hit a ball off your foot, you can use a certain vernacular starting with F, and you're not going to get thrown out of the game. But if you direct that vernacular to the umpire, you're going to get thrown out. So, I think depending on what was said and how it was said. Now,
I got to tell you, I disagree with the termination. I was surprised at this, unless there was a long history, just because, and look, a severe, let me quote the terms, but severe, out of character response by somebody tells you that something's going on with them, right? Now, look, maybe they were just tired. They got up twice, or maybe they're tired of, there's a long history of this, whatever it is. It seems to me the municipality now has an opportunity. Let me say that instead of saying it's a burden, but has the opportunity to assist somebody and help them with clearly their frustration, their anger, and all they've done is fired them, probably made it worse. We aren't looking out for our own. And I get it. It's a city. The city doesn't care, reputation. But honestly, A, what's the harm, right? So somebody got mad at a patient. It happens all the time. Is that really a terminable offense would have been my first issue. And two, why don't we look to the person who did it and say, maybe there's something more going on with this employer. Maybe she's taking too much overtime. Maybe, there's something else that maybe the municipality could have helped with.
Yeah, I think what you just put your finger on is something I call the binary decision with discipline, that very often we see it as an opportunity to intervene with some people, but the exact same thing can be an opportunity to get rid of somebody we want to get rid of. And it goes one way or the other. And we're really going to be intellectually honest about this. We want to be consistent and not just go in one direction when we like somebody, in a different direction when we don't like somebody. We've got to find a way to, get our whatever's driving that binary decision and, make a fair decision as leaders. And it's tough. It's something that everybody, I think, struggles with.
Yep. But we should be better. Okay. So let's go to Houston, home of the floods. I think it's flooding in Houston. This is a good example of a bread and butter fire department lawsuit, right? And it's I'll make it a little more general, even though it's in the city of Houston, right? But basically, the fire department responds to a person, puts the person in the stretcher, buckles the stretcher, is being careful. That's important. And then wheels the person down. The driveway changes grade, and the stretcher tips over.
And
this
she's
was an
94 years old.
Yeah. And instead of going to the regular hospital they're going to, they realize, okay, we should go to a trauma center appropriately. They head to the trauma center and the person never wakes up and dies. Look, I mean, your head's not cushioned in any way from these things that fall. But, and not knocking the stretcher manufacturers, when I was in EMS in 88 and then forward, we started with aluminum stretchers and they weighed like 30 pounds. And the only heavy thing to lift them was the patient. Now we have these auto lift stretchers, which is great for lifting, but they're like 100 and some odd pounds and they're awkward. You got the battery on one side, we got, bags on another side. It's just awkward. And they're not very wide, right? They don't really flare out because we don't have the room in the ambulance for them to do that. So they're narrow by design and they're tippy. That's just my experience, and they're heavy and they're awkward. So nonetheless, not this case, but maybe that was a reason. In any event, they sued. Understandably, the city gets sued. And what the court basically holds is very common to a lot of states, right? Look, there's governmental immunity. You can't sue unless we say you can. Well, the government said you can sue in certain cases, such as if you violated a statute. Here, the plaintiff tried to say you violated a statute. The city was successful in saying we didn't do anything wrong and we didn't violate statute. And the court said there's no jurisdiction for any court to hear this because there's immunity. So we're stealing the case and throwing it out. There's immunity. The governmental immunity protects you. You didn't violate a statute. And that's the end of it, right?
Well, and I think the other part here is that we're making an assumption that the level of fault on the part of the medics was at worst negligence.
Right.
And it was not gross negligence. It was not recklessness. It wasn't like they pushed the stretcher down a hill and were reckless.
And they strapped the person in, which is the reason we're covering that, right? They did attempt to act carefully, right? The gross negligence for most definitions means you didn't even attempt to act carefully. Negligence is you didn't act carefully, right? Much easier to prove. Here, maybe they didn't act carefully. But as you said, they certainly attempted to act carefully, and they certainly weren't reckless, right? Their conduct wasn't so likely to cause injury. It was almost intentional, the definition of recklessness or willful. And so I agree, that would change. They did allege gross negligence.
And the court said it's not even close. It's
right.
At worst negligence.
Right. So when you try, I always use as an example that this would be a good example during the seatbelts. I always use an example of intubation, right? I intubated, I auscultated, but it went down the wrong tube. Okay, well, I attempted to be careful. I just got it wrong. I may have been negligent, but I wasn't grossly negligent. Immunity is going to keep applying.
Yeah.
Okay. Let us end up in LA. This is a good one to talk about, really cursory, but on what comes next. So in LA, we have a firefighter, and I think his second lawsuit against the city, third lawsuit, maybe?
Second against the city, at least as far as my data, second lawsuit against the city, third lawsuit total in this area, because he initially filed suit against a black female firefighter who made some threats against him. He sued her to get a restraining order.
Right.
So that was that's what kicked it off. She apparently, at least according to what I've read in the complaints, she made some threats toward him, said she was going to blow him up or something to that nature, some sort of vague kind of thing. And that she said if he was a woman, that she would have beaten him up. So there was some sort of threat of harm, which, you change the facts a little bit. And, a guy says it to a gal, and now we're in a different scenario, but she says it to him, and he gets a restraining order, tries to get a restraining order. And then he initially had some retaliation against him. So he filed a suit. Now that was filed back in 2018. Okay. So he filed suit in 2018. And now he's filing this other suit alleging that the retaliation is continuing. He's been passed over for promotion and so on.
Well, and so he then lists about, staring at my bullet point, probably 15 different things. I'm not transferred to a station where I could get a better chance for promotion, or you're moving my shifts. I'm all sorts of things. You're harassing me. People are saying things.
I'm sure the other firefighters would never say anything about this.
No, not at all. But he lists about 15 things which he says is happening to him because of this. So he'll get by a motion to dismiss, right? What's going to happen from here, and this is, again, just like a 101 lawsuit to see, and you and I've talked a couple times about the burden shifting analysis, which is really good. The burden now shifts to the employer to say, hey, maybe all these things are true, but there's a non-retaliatory reason for them, non-discriminatory reason for them. And the city's going to have to show that they acted blind as to his complaints, right, when they made all of these decisions, or they're just not true. So that's where this happens. And, we saw, it was last week, the week before, City won, saying, look, these things may have happened, but we had a reason to do every one of them. We denied him sick leave because of this, denied him vacation because of that. Here's the same thing. So I would urge, if we had to put a learning point here, I think I would urge, when you deny somebody a promotion, maybe, I'm sure you have good notes, right? But when you deny someone a transfer, you deny someone a request, are you making notes as to the reason why? And short of saying, well, yeah, because this person did something I didn't like and I'm retaliating against them, if you have a legitimate reason why you did it, write it down so that years later, or a year later, when they allege, well, this pattern's been going on for years, you can pull out your notes and say, listen, at the time I did it because of this. I think that's your best practice. And I know writing things down people don't love doing it. But I write everything down because I'm just not going to remember things. And you think you're going to remember things a year, 3 years later, you're not. You write everything down. If there is an accident, the moment an accident happens, write everything down you remember. Give it to your attorney, give it to whatever, but write it all down. Same thing here. You made a decision. You could have had 15 different reasons why you did these things. And it could have been John Smith was more deserving, or there wasn't an open shift, or somebody was more senior to you, so you didn't get this. But no one's going to remember it, right, years later. And then you're going to be like, I don't remember why I made that decision. And that's going to hurt you. So and then if you are the one who made those decisions, let's say you're a battalion chief or something, and you can't justify why you made that decision years later, now maybe you look like the racist. Maybe you look like the one who's retaliating. That's not good for your career. So when you make denial decisions, not any decision, buy some more 4x4s, right? When you make decisions, for example, one of the things I love doing was I got to promote people, right? Our career staff to lieutenant. But when I didn't accept somebody, we wrote down the reasons, or we had a score chart, right? And that's what I prefer people use, points, right? And just save the points. Somebody got more points than you. That was it. Some were objective, some were subjective. In any event, write stuff down. Preserve your reasoning for decisions you think are going to get challenged, or you may have reasonably may get challenged.
You know, one of the things I think that officers have got to understand is that when someone alleges either retaliation or a complaint, and usually before we have retaliation, we have some sort of a complaint. In this case, he's alleging that he's being threatened and harassed, and so on. That person is different. And officers need to recognize that. Okay. And here's, I'll give you the metaphor. I think I use this metaphor a lot, but it's kind of like if Mrs. Smith lives in a fire resistant building, concrete walls, concrete ceilings and floors. Okay. She has a fire in that, we're going to provide a certain service to her. She's Mrs. Smith. She lives in fire resistant building. Mrs. Jones lives in a lightweight wood truss building.
And she's a hoarder.
And she's a hoarder. Okay. So now we're going to provide a service to her, but it's going to be a little bit different. And it's not because we don't like Mrs. Smith or Mrs. Jones, or we're providing a better service, but we recognize as part of our size up that there's a difference here. Okay. Well, the same thing applies to people. And when someone has filed a complaint, whether it's sexual harassment, race discrimination, or whatever, we as officers, we've got to recognize that they're different. And maybe a comment by a colleague or a joke that takes place in the station related to that complaint now, maybe before they file the complaint, it's not that big a deal. It is a big deal once they've filed the complaint because it looks like retaliation. And I know I was joking about this particular firefighter, but I can just imagine, you know, when I was with Providence, they would be torturing this guy in the firehouse.
Yeah.
You know, or you're really scared. You wouldn't get a restraining order. Boo, you must be really scared of her, right? You know, and they would be absolutely torturing this guy. And he'd be going, okay. And he's writing it all down. And no one is going to intervene in it.
Right.
And now he's got a case for retaliation. So I think that there's a training component here. That's my point. And our officers have got to recognize that when someone's filed a complaint, the company officers in particular and the chiefs that are in the firehouses got to stop that from happening. And, you know, at least recognizing the distinction is important.
You know, all these, you do them, I do them, you know, Frank Recruso, all these people do these leadership, right? Lectures and seminars and all that. And I'm wondering how much we all talk about the stand up and be the person to prevent, you prevent two things. You prevent the lawsuit, but you prevent that conduct from happening. And when you've been made, right, from internal, which is hard. So people from lieutenant, right, they're learned to be the boss, but they came up from among their friends. They did the same conduct. They made these stupid jokes. They harassed people. And now all of a sudden they're like, okay, I'm observing something, but now it's on me if I don't stop it. And they either go right or left, right? They either stop it or they don't stop it because I want to be their friend, not their boss. Or if I'm their boss, I'm afraid they're going to call me on the carpet for it because I was doing the same stupid stuff when I was just a firefighter.
But
and
very, very often the peer group that is doing the retaliating is the more powerful peer group and the one that the officer wants to stay friendly with at the expense of the outcast, you know, who may be the victim of the comments and jokes and different things. So the officer chooses to say, I'm going to make 8 people happy. So I'm not going to take care of the one person who's being picked on. Okay. And it's not happening at a conscious level. That these are decisions that the officer just says, you know, that person's a pain in the butt and I'm going to let them, they deserve what they're getting. They deserve the harassment that they're getting. And I'm just going to let them suffer through it.
well, you know, and then there's the, not just the deserve part, but I can't believe you're offended. You kept smiling. You kept laughing every time we picked on you. You kept saying, ha, ha, ha. And you would go back at us and you didn't leave or right. And what people think is, oh, it's just jokes. When that goes in front of a jury and those same words are repeated and you did this for X years, X months, X whatever, it ain't going to sound like a joke, right? I mean, I can't, even in my own department, way long ago, so a good friend of mine was just making Jewish jokes to me. And, what do you expect me to do? He's my lieutenant at the time, whatever, 15, 20 years ago. And I'm laughing. And finally it got to the point where I went to our chaplain and said, rather than make this disciplinary, I just wonder if you can intervene. And the guy comes to me and said, I can't believe you were offended. I didn't know. Why didn't you just say something? Because I shouldn't have to. And I think that's the point. If you are thinking that somebody will tell you they're offended in front of a bunch of your peers, fat freaking chance. Just cut the jokes. And why is it that firefighters have to watch pornographic crap on TV at the station? We have to tell the dumbest, most offensive jokes. We have to draw phallic symbols on pictures. Why is that level of stupidity reserved for the fire service? Why do we have to do it? Just stop it. You're a lawsuit waiting to happen.
Amen.
That's all I got.
All right. And I think that will wrap it up for another edition of Fire Law Roundup.